We shall make a start now. Um, Thank you, ladies and gentlemen, for joining us this morning for this session on legal aspects of derivative transactions, in particular netting arrangements in the GCC region, or a lack thereof based on the current legislations and the rules in these states. We'll also be covering certain selective financial free zones and their netting legislations. My name is Mamoon Khan, and I'm a partner in the banking and finance department at the firm in the Dubai office. And I'm joined by our senior counsels, Madhurima Basu and Muhammad Ahmad Yassin, who are subject matter experts and will provide an overview of the current netting rules in each of the designated jurisdictions, as well as the necessary interplay with the applicable bankruptcy and insolvency laws, which may impact any set of arrangements in such transactions. Before we start, a bit about our derivatives practice within the banking and finance department. We are very much committed to this area of practice in the region with requisite resources and subject matter expertise on netting arrangements in particular. We regularly act for and advise treasury teams at banks, financial institutions, and market counterparties in the region, as well as foreign financial institutions who enter into master agreements with local counterparties. In terms of our services, the same range from advising and negotiating the necessary derivative documentation, including master agreements, collateral and credit support arrangements and documentation, issuing jurisdictional netting opinions, advising on corporate capacity, and in particular, where there are sovereign counterparties involved. Recently, we've been advising on LIBOR transition in the master agreements. And lastly, we are now also working very closely with industry associations such as ISDA and ICMA to formulate netting legal opinions for the region. So with that introduction, I will now hand over to my colleagues Madhurima and Ahmad to introduce themselves and take us through the slides for each of the jurisdictions. Just a housekeeping note, we will also have some time at the end for question and answers, and you can post your questions in the chat section, which we will then address accordingly. I'll hand over to Madhurima now.
Thank you, Mamoon. Hi, I'm Madhurima, and I'm a senior counsel in Ultimimi's banking and finance practice. I look after derivatives and market contracts, negotiation and advising on a regional basis. So to the importance of closeout netting. Now, to summarize, what exactly is closeout netting? And I'm sure most of you know, but just to give you a very, very short summary, it's a closeout netting it's a technique to determine the net obligations of a defaulting counterparty in a derivatives or market transaction. Now, it effectively involves termination of outstanding transactions, valuation of the unperformed obligations relating to those outstanding transactions, and determination of a net value of the net balance around this. So the way this net balance is calculated is to aggregate and net the values owed to the non-defaulting party and the values owed to the defaulting party. And once you aggregate and net it, you'll be able to come to a single closeout amount, which amount may be positive or negative. And depending on where we are, one party will pay that amount to the other party. Now, conceptually, it sounds very simple, but then why are we here today? So the closeout netting is something that needs to be addressed through contracts and netting agreements on one side and local netting legislation on the other. Now, if you have both available, then closeout netting can provide for high degree of certainty in default situations. Now, netting is also recognized for regulatory capital purposes. So it can help you reduce your capital requirements once both the contract and the law works hand in hand. But the most important point of all is that it helps in reducing risk on both sides. Now, I'll just address one question that comes to me very frequently, that Is it a question of parity when you're negotiating ISDA agreements, whether you can net, you can't net, whether you have automatic early termination or not? But effectively, this is not really a question of parity. It's something you need to look to the corporate status and jurisdiction of your counterparty, which is what we will be doing here in a bit more detail today. Now, in the GCC, as you're aware, there are some jurisdictions which have adopted netting legislations and some where it is under consideration and actually it's very close to being adopted. But there are some other jurisdictions as well where the netting legislations are not in place, and we would be looking to the general body of law which can aid in netting in the absence of such specific netting legislation. Now, I'll hand over to my colleague Ahmad to take us through the detailed position in the UAE and its free zone. And then later on, I will go through the other jurisdictions in the region as well. Ahmad, over to you.
Thank you, Madhurima. Hi, everyone. Thank you for joining us in this session. My name is Mohammad Ahmad Yassin, and I'm a senior counsel in the banking and finance team of Al-Tamimi. I support Al-Tamimi's derivative practice out of the DIFC office. As Madhurima mentioned, legislation is necessary to give legal certainty to close out netting, in particular following the commencement of insolvency proceedings. As some of you may be aware, UAE is a netting-friendly jurisdiction, with each of mainland UAE, the Dubai International Financial Center, and the Abu Dhabi Global Market having separate netting legislation. In mainland UAE, netting is covered under the Federal Netting Law number 10 of 2018. The Federal Netting Law is substantially based on ISDA's Model Netting Act and applies to all netting agreements, qualified financial contracts, and collateral arrangements, including title transfer collateral arrangements, which are entered into by any person in the UAE. It's important to note the word person as defined in the Federal Netting Law includes both natural persons and legal persons. The Federal Netting Law does not, however, apply in the DIFC and ADGM, which have their own netting legislations, which I will cover in the next slides. In terms of key concepts of the Federal Netting Law, and in particular, those of netting, netting agreements, qualified financial contracts, and collateral arrangements, these key concepts, including the definitions thereof, are largely consistent with those present in ISDA's Model Netting Act, and in some cases, the UAE Federal Netting Law further expands and elaborates on these concepts, making them more encompassing. The key features of the Federal Netting Law, as you would expect, are substantially the same as in ISDA's Model Netting Act. Some of these being, number one, netting agreements are final and enforceable in accordance with their terms, including against an insolvent party, and where applicable, against a guarantor or security provider. It provides that netting agreements will not be stayed, avoided, or otherwise limited by any provision of law relating to bankruptcy or by virtue of appointment of or any action of insolvency officers. It states that qualified financial contracts shall not be considered void, unenforceable, or not final for any reason relating to aleatory contracts referred to in the UAE Civil Transactions Law or principles of gharar under Sharia. Interestingly, the Federal Netting Law does not refer to the gambling provisions under the UAE Penal Code. However, our considered position based on other provisions of the Federal Netting Law is that it is very unlikely that a contract party would be able to successfully use gambling provisions under the Penal Code to challenge an otherwise enforceable netting agreement or qualified financial contracts for that matter. The Federal Netting Law also contains certain limitations on the powers of insolvency officers, as you would expect for netting agreements, such as any power to prevent termination, liquidation, and or acceleration of payment or delivery obligations or rights, or subject to certain exemptions, powers of an insolvency officer to avoid any transaction on grounds of it constituting preference, in particular during suspect periods. The federal letting law also disapplies any provisions in UAE insolvency laws which would otherwise limit the exercise of rights of set-off, to offset, or net out obligations or payment amounts or any such values between the parties to a netting agreement. In terms of preemption, it provides that no stay, injunction, avoidance, moratorium, or similar proceedings or order, whether issued or granted by a court, insolvency officer, or otherwise, shall limit or delay application or performance of an enforceable netting agreement and transactions entered into thereunder. Finally, the federal netting law also includes provisions for closeout netting on multi-branch basis, which are an optional section in the ISDA's Model Netting Act. It is also interesting to note that there is a new federal bankruptcy law which is coming into force on 1st May 2024. The new federal bankruptcy law expressly recognizes the federal netting law and provides that all netting agreements are final and enforceable in accordance with their terms, and anything in relation to netting which is not covered in the new bankruptcy law will be subject to the federal netting law. Moving on to the DIFC now. So DIFC, as I mentioned, is also a netting-friendly jurisdiction, as is mainland UAE. In the DIFC, netting is covered under DIFC Law number 2 of 2014. The DIFC netting law is also substantially based on ISDA's Model Netting Act and applies to all netting agreements, qualified financial instruments, and collateral arrangements, including title transfer collateral arrangements, which are either governed by DIFC law or are entered into by any person incorporated or registered in the DIFC. An important point to note here is people residing in the DIFC will be subject to the federal netting law. The DIFC netting law only extends to legal persons. In terms of key concepts of the DIFC netting law, such as those of netting arrangements, qualified financial instruments, and collateral arrangements, again, they follow the same principle, same definitions, or largely same principles and definitions as are present in the ISDA Model Netting Act. The key features of the DIFC netting law are also essentially the same as in the federal netting law and the ISDA Model Netting Act, being netting agreements being final and enforceable in accordance with their terms, not subject to stay or moratorium or any action of liquidators, provide similar protections or limitations on the powers of liquidators as in the federal netting law. This applies DIFC insolvency laws, which will limit the rights of set-off to offset or to net out obligations. There is, however, one additional key point, which is within the DIFC netting law and not present within the federal netting law. Consistent with the ISDA Model Netting Act, the DIFC netting law provides where some transactions under a netting agreement are not qualified financial instruments, or that the netting agreement contains provisions relating to agreements, contracts, or transactions that are not qualified financial transactions, such an agreement would still be a netting agreement for the purposes of the DIFC netting law and will apply to those transactions which fall within the definition of qualified financial instruments in the DIFC netting law. This is a very key consideration and specifically highlighted in ISDA's Model Netting Act as well. The DIFC netting law also provides similar coverage to collateral arrangements. Now, unlike mainland UAE, DIFC also has separate financial collateral regulations. The financial collateral regulations seek to modify and supplement the DIFC law of security in relation to certain rules therein on attachment, perfection, and enforcement of financial collateral. The DIFC financial collateral regulations recognize both title transfer financial collateral arrangements and security interest financial collateral arrangements. Financial collateral as a term is broadly defined into two categories. One is money held in or credited to an account, including any rights to receive such monies or rights in the underlying accounts. Second is financial property held in an account, such as shares, bonds, money market instruments, or other types of securities or debt instruments, including rights therein. In general, to perfect a security interest over such type of financial collateral, there is no requirement to register or to take any formal act in the DIFC. The financial collateral regulations also contains principles in relation to determining priority of interest in financial collateral and includes certain rights of enforcement of financial collateral. Such rights of enforcement include, in case of financial property, selling such financial property and applying the net proceeds towards the discharge of secured obligations, to realize or appropriate the financial collateral as the security holder's own property in accordance with the terms of the collateral arrangement, in case of money, exercising rights of set-off. And in each of these cases, the financial collateral regulations clarify that there is no requirement to send any prior notice to or to seek any prior consent from the security provider or to obtain an order of a DIFC court in order to enforce financial collateral. As you would be aware that in the UAE, there are no financial collateral regulations. So the analysis largely falls down to the UAE securities laws in terms of how collateral will be treated, how it will be perfected. And largely speaking, we do end up leading to the same analysis or more or less same analysis under the DIFC legislation, but that's a topic for a different day. In the ADGM now, ADGM is also a netting friendly jurisdiction. In the ADGM, the netting provisions are covered essentially under Part 7 of the ADGM Insolvency Regulations 2022. These netting provisions in the ADGM Insolvency Regulations also are based on or substantially based on ISDA's Model Netting Act and applies to all netting agreements, qualified financial contracts, collateral arrangements, and title transfer collateral arrangements, which are either governed by ADGM law or are entered into by any person incorporated or licensed in the ADGM. Once again, the ADGM netting provisions only apply to legal persons. They do not extend to individuals for which the UAE federal netting law applies. Similar to, in terms of key concepts and in terms of key features, the ADGM netting provisions are substantially the same and provide the same coverage as those in the UAE federal netting law, the DIFC netting law, and ISDA Model Netting Act. Chapter 3 of Part 7 of ADGM Insolvency Regulations also contains provisions in relation to collateral arrangements, which are more or less similar to those found in the DIFC Financial Collateral Regulations and provide substantially the same coverage and same rights in relation to financial collateral. In general, in order to perfect a security interest over financial collateral, no registration requirements apply, nor are there any other formal acts to be followed. So this was just a quick overview of the three jurisdictions in the UAE, being mainland UAE, ADGM, and DIFC, and in terms of the netting position in each of these three jurisdictions. To very quickly summarize, each of these three jurisdictions are netting-friendly jurisdictions. Their netting legislation is based on ISDA's Model Netting Act and provides coverage which you would expect in most jurisdictions a netting legislation should provide. ISDA has also commissioned market opinions in all of these three jurisdictions, which are positive opinions, and we at Al-Tamimi have supported a number of financial institutions in terms of issuing bespoke opinions on a number of matters. including on entities which fall outside the scope of these market opinions. I will now hand over to Madhurima to walk us through other jurisdictions.
Thank you, Ahmad. Now, let's move on to the Kingdom of Saudi Arabia. Now, let us first actually talk about the forthcoming netting regulations in Saudi Arabia rather than the current position, because the netting regulation should be issued quite quickly. So the first thing to note is it's not a legislation, it is a regulation, and it will be issued by SAMA under Article 4 of the Saudi Central Bank law. SAMA, as you all are aware, is the Saudi Central Bank. Just 1 second, please, I apologize. Now, the Saudi bankruptcy law provides that no set-off can be done across different transactions once proceedings, or rather bankruptcy proceedings, have been commenced. But there are exceptions to that. And one such exception is about financial transactions. And these netting regulations that will come into force soon will slide right under that. The SAMA draft netting regulations are also closely based on the ISDA's Model Netting Act. And as such, it has similar provisions like enforceability of qualified financial contracts, enforceability of netting arrangements, curtailing some rights of the liquidators when it comes to netting agreements, etc. Very similar to what you've already seen in other jurisdictions, as well as ISDA's Model Netting Act. The crucial point is, it applies where at least one party is a SAMA regulated entity, which means that if it is not between a bank or any other entity which is regulated by SAMA, or between two corporates, this will not apply. And moreover, individuals are excluded. So persons are usually just corporate persons. As you can appreciate, SAMA is only regulating banks. Now, you also may be aware that there are certain types of CFDs and derivatives in Saudi Arabia which come under the purview of the Capital Markets Authority. Now, this regulation in its current form will not apply to entities which are supervised by the CMA. But we understand that CMA will also come up with its own regulation on netting in due course. We haven't seen a draft of that yet. Now, coming to SAMA's netting regulation, the key point is, what are the qualified financial contracts? Now, there's a whole list of qualified financial contracts in Annex 1 of the netting regulations. It broadly covers all traditional derivatives that we've come across, but certain very new kind of trades like carbon credits are not explicitly included. Now, SAMA will have the right to designate further transactions as QFC, so we assume that this will be clarified in future. The draft regulations include all standard provisions, as I said, from ISDA's model netting law, and it also includes multi-branch provisions. And regarding collateral, it recognizes financial collateral arrangements, and it can be realized and liquidated without consent or notice when done in a commercially reasonable manner, similar to what you would see in other netting legislations as well. Now, as I said right in the beginning, it's not currently in force. It will come into force in some time. So just let's take a look at the current status. The last draft that we have seen was published for public consultation on SAMA's website in November 2023. We understand from industry sources that its publication is imminent, so we believe that this will come into force very quickly. We will, of course, be doing an update once the netting regulations come into force in Saudi. Now, moving on to Bahrain. Now, Bahrain is a very interesting case study for us. The Central Bank of Bahrain was one of the first movers in the region, and it came up with Resolution 44 of 2014. It's a netting regulation that was issued by the Central Bank of Bahrain. Again, it's based on ISDA's model netting law. It includes all the standard provisions you would expect on enforceability of qualified financial contracts, enforceability of netting and collateral arrangements surrounding that. it apply, and as well as liquidator authorities regarding netting laws, netting regulations, I mean. It applies to different types of corporates, but again, similar to some other netting laws, it doesn't apply to individuals. It included multi-branch provisions, and it also includes the standard collateral provision that it can be liquidated and realized without consent. However, as you all may be aware, that some years ago, Bahrain had a very interesting case on derivatives where the netting regulations were not properly applied the way it should have been. And accordingly, Bahrain is working on a new netting law, which would come in as a legislation rather than a regulation from the Central Bank of Bahrain. Once that is passed, we believe that that the Central Bank of Bahrain netting regulation would be replaced. We have seen a 2017 draft legislation for this, and again, it aligns to ISA's model netting law. It has all the provisions that you would expect, including enforceability of netting agreements, qualified financial contracts, collateral arrangements, etc. But one key difference is that it does not include multi-branch provisions. Now, quickly moving on to some other jurisdictions, and I will start with Kuwait, where I'm based. Now, in Kuwait, there is currently no specific netting legislation or regulation. As far as we are aware, there's nothing in the pipeline as well. And this is not a topic that has been debated or litigated upon in Kuwait, again, as far as we are aware, because court decisions are confidential here in Kuwait. Now, because of this, there is no really a list of qualified financial contracts which is really enforceable. So let's take a minute to discuss on the enforceability of OTC derivatives here in Kuwait. Now, similar to other jurisdictions, gambling is prohibited here in Kuwait law under the Penal Code, and any transaction which is can be void based on public policy reasons. Now, we have considered both of this in light of derivatives transactions, and our considered view is derivatives will be considered commercial activity, and as such, it should be enforceable here in Kuwait unless it is speculative. Now, if you have a completely speculative transaction, now that's something that might come under these rules, but a standard derivative with underlying commercial risk that is being hedged should be enforceable here in Kuwait. There should be no issues surrounding its enforceability. Now, again, because Kuwait doesn't have a specific netting legislation, we will look to set off to see how we can aid netting here. Now, the first is the pre-insolvency set-off, which of course is permissible based on civil code. But however, the post-insolvency set-off is something that is now housed under the bankruptcy law. This is a bankruptcy law that came about in 2020 and came into force in the middle of 2021. Previously, the bankruptcy provisions were in the commercial code, but once the new bankruptcy law came in, those provisions no longer applied. Now, under the bankruptcy law, set-off can be done as a part of a court-approved preventive settlement proposal or restructuring plan, or approval of a bankruptcy code once it is done, once the bankruptcy procedures have been opened. Now, this causes some sort of a restriction in the current state of set-off, though you can try to apply automatic early termination, which would aid in the set-off position. The key point to note here is that the bankruptcy law applies to corporates, it applies to individuals who are traders, but it doesn't apply to all types of entities. And so all entities should be analyzed on a case-by-case basis, especially when they are sovereign or state-owned entities. Now, just to touch upon the collateral situation here in Kuwait. Now, Kuwait law recognizes a foreign law governed collateral arrangement as a valid contract, but when it comes to the actual assets, it recognizes the concept or the principle of lex situs, which means the law that will prevail is the law where the assets are based. So the perfection and enforcement of the collateral will depend on where the assets are based. To that extent, if you have Kuwait assets, Kuwait law would need to be followed for perfection and enforcement, which could be a bit complicated. And in some situations, we have seen that the banks try to take other types of securities as well, even when you're thinking about derivatives arrangements, such as a pledge. But again, this needs to go through the process, to go through the ministry process. So there can be issues around that. But again, that's probably for another session, and maybe we can take it off offline given the nuances involved. Now, a quick look at Oman. Again, similar to Kuwait, Oman doesn't have any specific netting legislation, and we are not aware of any current legislation in the pipeline or whether this has been discussed in the courts. Again, in Oman as well, court decisions are private. Now, just to touch upon enforceability of OTC derivatives in Oman. Again, the civil code there states that the contract of gambling will be void, but our considered position is that if you have a commercial derivative which is not speculative, it is not going to be considered gambling and it should be enforceable. There should be no issues around it. Now, because there is no specific netting legislation, again, in Oman as well, we will look to set off, which should be applicable pre-insolvency, no issues around that. Now, post-insolvency, we need to look to the bankruptcy law here. Again, here the law came out in 2019 and it came into effect in 2020. Article 112 of the bankruptcy law states that no set-off will take place after adjudication of bankruptcy unless they are correlated. So you have the same cause restriction. But the key point to note here is bankruptcy law does not apply to all types of organizations. So you should consider your counterparty on a case-by-case basis. And at times, there will be certain special laws applicable to certain types of counterparties. Now, on the collateral front, again, Oman recognizes a foreign law governed collateral arrangements. But again, Oman too follows the principle of lex situs regarding perfection and enforcement of collateral. So you do need to look at where your underlying assets are located to see what law will apply. To the extent you have Omani security, Oman law would apply and the perfection needs to be done based on that. Now, very quick stop in Qatar. Very similar position to Kuwait and Oman. There is no specific netting legislation. As far as we are aware, there's no netting legislation in the pipeline as well. Here, again, enforceability of OTC derivatives is something that we have considered. And again, our considered view is it is extremely unlikely that derivatives would be treated as unenforceable when there's no speculation. It should be treated as a commercial contract, and there should be no issues surrounding its enforceability. Again, given the lack of netting, targeted netting legislation, we will look to set off to aid netting, and set off is recognized under the civil code. However, after an adjudication of bankruptcy, the commercial code will apply, which houses the bankruptcy provisions. Article 632 of the commercial code restricts set off unless there is a link or interrelation between the payment obligation of the bankrupt entity and the funds of the bankrupt entity that is in possession of the creditor. So the same cause or the interrelation is very crucial here as well. And that's something which should be considered on a case-by-case basis. Now, regarding Qatar law, especially when it comes to financial collateral, again, similar to Kuwait and Qatar, it recognizes foreign law governed collateral arrangement, but the principle of lex situs will apply for assets, especially for the perfection and enforcement. So again, it's a nuanced position that should be considered on a case-by-case basis, particularly based on where your assets are located. Now we'll move on to the Qatar Financial Center, which actually has its own netting regulations. The netting regulations came about in 2017, and as such, the position is netting friendly. It applies to various types of corporates and local branches of individuals. So just to keep in mind that the QFC netting regulations does not apply to individuals. This is very similar to what you have seen in other jurisdictions as well, so should not be a surprise, but definitely something to keep in mind. The netting provisions of the netting regulations are again broadly aligned to ISDA's model netting law, and very standard. There's a whole list of qualified financial contracts under the netting regulations. They are traditional types of derivatives, and this list can be amended by the QFC authority and the QFC regulatory authority as and when it is required. And moreover, the QFC also recognizes collateral provisions, and together with the netting regulation and the QFC security regulation, they provide greater certainty in collateral enforcement in the QFC. So just for a quick recap, for Saudi, we have the new netting regulation should come into force soon. Bahrain already has its netting regulation issued by the Central Bank of Bahrain, but we are expecting the netting law, the legislation should be passed quite quickly, hopefully very soon. Kuwait, Qatar, and Oman, there is no specific netting regulation, but we look through to the enforceability of qualified financial contracts, and as such, there isn't any problem unless it is speculative, in which case it needs to be considered on a case-by-case basis. There are some restrictions on set-off once insolvency has set in, but again, those need to be considered on a case-by-case basis. And finally, the QFC, which is again a netting-friendly jurisdiction, and with the netting regulation together with the QFC security regulations provide for greater certainty in collateral enforcement as well. I will now hand over to my colleague Mamoon to take us through the Q&A.
Thank you, Madhurima and Ahmad. Just before we can take a few questions, just wanted to highlight a few issues that have come up in our recent sort of discussions, certain market issues. I think one thing that's been highlighted is in relation to the financial collateral regulations for the DIFC and ADGM. So just one point to highlight that for the purposes of taking security onshore UAE, the provision is, the legal position is similar to what we've discussed for other states. If there is a secured asset onshore UAE, the financial collateral regulations of the ADGM and the DIFC would not apply, and they would have to be secured by way of local UAE law, i.e. the secure transactions law, or if it's a immovable asset based on the mortgage sort of regulations in each of the Emirates. Previously, we used to have a legal issue that arose prior to the netting law, that what are we, because I think that lenders tend to secure a full package. They would have the syndicated loan agreement and the hedging documentation to be secured by onshore security. And the challenge at that point we used to face was that what are we really securing? Because these are counterparty to counterparty obligations, and the local laws tend to secure a securable debt. But after the promulgation of the netting law, that sort of that issue has now been resolved. However, in terms of securing any hedging arrangements onshore, the local UAE laws would be applicable. Another question that's come up recently is that under the new UAE bankruptcy law, which will take effect in May, banks and financial institutions have been excluded, or central bank licensed institutions have been excluded. And in their place, the recovery plan regulations have been implemented. And one question comes up is that in terms of netting arrangements, what would be the, how would that be tackled from an insolvency perspective? At the moment, the recovery planning regulations, to the best of our knowledge, do not have any specific provision on netting arrangements. but there is a provision but there is a certain set of executive regulations which are required, which will be notified by the central bank, and there is an expectation that netting arrangements may be covered there. However, in the absence of that, there is a provision in the RPR which does talk about application of the bankruptcy law where applicable. So in the absence of the executive regulations, firstly, it would be there is quite a bit of discretionary power provided to the central bank to set out a certain plan and recognizing set of arrangements, and of course, at the same time, it will also adopt the current position in the bankruptcy law. We also understand that the provision in Oman is also fairly similar. Under the Omani bankruptcy law, banks and financial institutions are excluded, but there is no parallel provision on RPRs. So therefore, it comes down to the discretion of the Central Bank of Oman and the applicable court to accordingly apply. So these were a couple of updates we wanted to highlight. We've got 2 questions in the chat box. I think the first question is, Madhurima, is for yourself. I'll read it out. Assuming SAMA rules come out soon, what are the next steps that would be required for existing trades which are on the SPV? Would there be a novation through an ISDA side letter, or all these trades will have to be novated? Please, could you outline the process? I think it's a follow-up question, novation from SPV to Saudi head office entity. So
you
I'll
would
leave
go
that in.
through the standard novation process under the ISDA to re-domicile those trades back to the head office, because these were never branches. They are a separate legal entity. So you're novating the trade from one entity to another. We have actually done a lot of novations from head office to SPV and vice versa once the UAE netting legislation came out. So please do reach out if you need any assistance on that.
There are no other questions in the chat.
I think it's also worth saying that we are recording this session. So if you do need to refer back to that, please do let us know. We're happy to circulate a link.
I think we can wait. I think, as Madhurima said, that the session is recorded. So we will be circulating the recording to this group. I think with that, I know everybody has a busy schedule this morning, so I will end. And I thank you again for everyone joining us today. We hope you found the session useful. Of course, as discussed earlier, we'll be available on email or call for any follow-up questions or queries that you may have based on today's session. Therefore, please feel free to reach out to Madhurima, Ahmad, or myself at your convenience if you would like to discuss any aspects of the session today. We do not want to leave it here. We do intend to follow up this session with any further legal developments in this area, including issuance of any new netting legislations in the region or amendment or to the existing legislations. What we will do is we will be sending out client alerts in the course of the year. And there is an article that is being discussed, which will be published in our law update on the comparative analysis we've done. I think one legislation is something that banks should be mindful of, or the party mindful of, is for the UAE. As you're aware, the commercial gaming law will be issued, we understand, shortly. There is, to our understanding, there's references to a contract of differences in there. Whilst it may not directly apply to banks, but that one legislation, as and when it comes out, we'll be doing a client alert on it anyway, may cover certain aspects of contract of differences, which may be useful to banks. So I think with that, we'll be closing this session, and thank you again for joining us today.
Thank you. Please do reach out to us for any assistance on any derivatives matter, whether that relates to netting issues under local law or just standard negotiation or advising from an English law perspective. just wanted to highlight that we have registrar capabilities and are able to advise on that basis as well.
Thank you.